If you are served with a Roseboro notice, don't panic. Certainly don't ignore it. Respond.
Hi, everybody. Advocate Lucinda. I had a pro se to contact me and say that they received a Roseboro motion. And the individual was concerned because they didn't get an opportunity to conduct discovery. And it's a valid question because typically, when a lawsuit is filed, both the plaintiff and opposing counsel will engage in a conference during which they will discuss discovery, when it begins, parameters of discovery, and other matters. They then go before the judge. The judge looks at what they discussed in the conference, which was signed, and which the parties will follow throughout litigation. And that's what we're going to talk about today. The Roseboro motion and responding to the defendant's summary motion. So let's get started.
So before we get into the Roseboro's discussion, let me just remind you of the Federal Rules of Civil Procedure 56, summary judgment, time to file a motion. This is critical. Unless a different time is set by local rule or the court orders otherwise, a party may file a motion for summary judgment at any time until 30 days after the close of all discovery. This is why I always say read the local rules, because the jurisdiction from jurisdiction, things might be done a little differently. But let me say at the outset, Pro Se, move as quickly as you can to get a scheduling order in place. That is critical. Let's look at the definition of a Roseboro notice. It's a notice to the pro se advising him to respond to the government's motion for summary judgment, informing him otherwise the case may be dismissed. Now, you know I like to illustrate my videos with case law because they tend to make the issue more clear. And the case that we're going to look at today, in fact, where this Roseboro motion came from, is an actual case, Roseboro versus Garrison. And that's found at 528 Federal 2nd, 309. It's a Fourth Circuit case, and it's a 1975 case. Mr. Roseboro was an inmate at the Central Prison in North Carolina. He sued under 42 U.S.C. 1983, wherein he alleged that the defendant violated his constitutional rights. Now, the defendant filed a summary motion. He submitted his own affidavit and the affidavits of others to support his defense. And of course, the affidavit and the other affidavits of others related to the allegations in Roseboro's complaint. However, Roseboro failed to file any counter affidavit controverting those submitted by the defendant. The court in Roseboro found the affidavits, defendants' affidavits, were in compliance with Rule 56E of the Federal Rules of Civil Procedure, and the court concluded that summary judgment was appropriate. Remember, Federal Rule 56E refers to the party's obligation to support a fact You can't make a factual statement and not support it. And of course, an affidavit is one way of supporting a fact. Roseboro appealed. He argued summary disposition of his case was improper. And what he was alleging is that he was not advised of his right to file counter affidavits. And apparently, the appellate court agreed with him. So the appellate court reversed the district court's ruling. In its ruling, it relied on an earlier case to explain why it reversed. Hudson versus Hardy, 134 U.S. Appeals District Court. That is a 1968 case. The court stated, "We hold that before entering summary judgment against appellant, the district court, as a bare minimum, should have provided him with fair notice of the requirements of the summary judgment rule. We stress the need for a form of notice sufficiently understandable to one in appellant's circumstances, fairly to apprise him of what is required." And the court went on further to say, since Roseboro was not represented by counsel in this case, and there is nothing in the record to indicate that he was notified of his right or responsibility with respect to the defendant's motion, the judgment of the district court must be reversed and the case remanded for further proceedings consistent with this opinion. Takeaway 1. Pro se. After you have filed the lawsuit, pursue a scheduling order as immediately as possible to secure an opportunity to propound discovery. Because remember, once a scheduling order is in place, it entails discovery, when discovery begins, when it ends, as well as other matters. And also, remember to read Federal Rules of Civil Procedure 56 and local rules to see what your district's practices are. Okay? Takeaway 2. Pro se. If you receive a Roseboro notice or any notice from the court to respond, respond. If you have nothing but an affidavit, you submit that affidavit in response to the defendant's summary motion. Okay? Takeaway 3. If the defendant files a summary motion, pro se, don't wait on the court to issue a Roseboro notice. Respond to the motion, because the court apparently may not be required to issue the notice. Respond to the motion. And takeaway 4. Listen, affidavits are powerful and they are effective. Pro se. Your affidavit and the affidavit of others who can supply information to the court that is relevant to the complaint could help you overcome the defendant's motion. Also, if you should ever get a summary motion, you need to really study Federal Rules of Civil Procedure 56, and it particularly Rules 56C through E, because it provides you with information that is very valuable, there are other documents and evidence besides an affidavit that you may be able to submit to the court to assist you in responding to the defendant's summary motion. You got to read it, okay? Critical. You know, I made this video because last week someone received a Roseboro motion. So that tells me that it has some relevance. And it appears that it depends on the circumstances, the cases, and it even appears it differs from jurisdiction to jurisdiction. So here's the point, pro se. Whether it's relevant in one jurisdiction or not, if you receive a summary motion from the defendant, respond. Okay? I hope this has been helpful to you. And I am Advocate Lucinda, your empowerment lawyer. And we'll see you next time. Take care.